This is part 2 of criminal law, looking at accomplice withdrawal. To avoid liability, they must repudiate prior aid and countermand prior assistance prior to chain of events in motion and unstoppable. Now, do not confuse accomplice withdrawal with withdrawal in inchoate crimes such as solicitation, conspiracy, attempt. Accessory after the fact knows a crime has been committed, acts to aid and or assist the felon. Assistance and or aid is given for purposes of avoiding apprehension. Looking at insanity, there are essentially 3 tests for insanity. Then the MPC merges 2 of them. You have the McNaughton test, the Irresistible-Impulse test, the Durham rule. You have MPC 401, which merges the McNaughton and the Irresistible-Impulse test. McNaughton test is the defendant is not guilty for a defect of reason. The defendant did not know either the nature and or quality of the act or wrongfulness of the act. Looking at insanity in the Irresistible-Impulse test, the defendant is not guilty for a lack of capacity for self-control. It is an impulse that the defendant cannot resist. Insanity in the Durham rule, this is the but-for test for insanity. The defendant is not guilty. The defendant would not have committed the act but for mental disease or defect. Insanity in the MPC 401, again, this combines McNaughton and Irresistible-Impulse test. Defendant is not guilty because at the time of the conduct, the defendant, as a result of mental disease defect, did not have capacity to appreciate wrongfulness of the act. And that's the MPC 401. Insanity and the burden of proof. Majority of jurisdictions place proving insanity on the defendant. They are split as to whether this is by a clear and convincing standard or a preponderance standard. Then courts are split as to whether the burden of persuasion moves the prosecution to the level of beyond a reasonable doubt, or the burden of persuasion remains on the defendant to the level of preponderance of the evidence. A little confusing in the old insanity. Ironic. Voluntary intoxication is not a defense when the intent is formed before intoxication, such as you decide to murder your girlfriend, you go out, get drunk, then you murder your girlfriend. Voluntary intoxication is not a defense for malice, recklessness, negligence, or strict liability crimes. It is a defense for specific intent crimes if intoxication is sufficient to prevent formation of the required intent, such as premeditation required for first-degree murder versus second-degree murder. Voluntary intoxication is a defense for general, specific intent and malice crimes. The intoxicating substance must be taken without knowledge of the intoxicating nature of the substance, or it must be taken under duress. Looking at immaturity and or infancy, under the common law, under the age of 7, you cannot be convicted. Between the ages of 7 and 14, there is a rebuttable presumption that you're incapable. Over the age of 14, under the common law, you could be charged as an adult. Statutes, generally, you're convictable between the ages of 11 and 14. Looking at homicide, you have common law, homicide, you have homicide justified by law, criminal homicide, and then excusable homicide. And those 3 classifications of homicide under the common law: justified by law, criminal, and excusable. Criminal homicides further include murder, voluntary manslaughter, involuntary manslaughter. Homicide is where a living person dies, a body need not be found, death may be established by circumstantial evidence. Under the common law, a fetus is not a living person. Causation in homicide, the defendant must be the actual and proximate cause of the death, meaning but for the defendant's act, and that the death was foreseeable, natural, and probable result of that act. Common law murder, Again, common law criminal homicide includes murder, voluntary manslaughter, involuntary manslaughter. Common law murder is the unlawful killing of a human being with malice of forethought. And malice of forethought means the intent to kill, the intent to inflict serious bodily injury, the intent to commit certain felonies, or reckless indifference to the high risk of human life. Where the intent is to commit certain felonies, this is the felony murder rule. Where it is reckless indifference to the high risk to human life, this is depraved heart murder. The intent in murder may be inferred if a deadly weapon is used. Why would you be using a deadly weapon if you didn't have the intent to kill somebody? That is the nature of the weapon. Looking at felony murder, traditional felonies that are tested are the BARK felonies, B-A-R-R-K felonies, burglary, arson, robbery, rape, kidnapping. Co-felons are vicariously liable, and there is no attempted felony murder. The victim must actually die. Defenses to felony murder are any defenses to the underlying felony, that the felony is not distinct from the killing itself, such as an aggravated battery, that death is not foreseeable, probable consequence of the felony. Another defense is that the death occurred after commission of the felony during flight from the scene. Now, where a bystander is killed during a felony murder charge or during commission of a felony, there are two theories to whether liability applies. So a bystander dies and they're shot by the victim or by the police or by somebody else, whatever. There's an agency theory and proximate cause theory. Under the agency theory, there is no liability. Under the proximate cause theory, death attaches to the felony. Death is a probable natural consequence. It's proximately caused by the felony. On the exam, use the proximate cause theory, meaning that death will attach to the felony. The death of the bystander will attach to the felony. And that concludes part 2 of criminal law.